Yeah, please.
All right. Next topic on our agenda is the proposal from the Equity and Disparity Workgroup to amend GR 12.2. This is also not on for action, but is a discussion item. So I'm going to turn it over to Governor Alex Stevens and the subcommittee chair, Laura Sierra.
Thank you very much, Executive Director Nevitt and President Clark. It's been my honor and a privilege to chair the Equity and Disparity Work Group. We've already presented to you a few months back one of our subcommittee's work, which was regarding access to courts, and that's now working its way through as a proposal with the Judicial Committee. So we're now here for the second half of the subcommittees, and that subcommittee focused its work on GR 12.2. And what we're doing here today is actually just to give at a high level what that proposal is, with the idea that we will come back to the Board of Governors, I believe, President Clark, in June for first read, and then we would come back subsequent to that for second read. This will be actually the beginnings of a long process, meaning after we do second read, if the Board of Governors approves the revisions, that is not the end of the story, because it's a approval to submit revisions to the GR 12.2C to the Supreme Court, and the Supreme Court will then take up through their process the consideration of the change to be made. So there will be then the effort through their processes, making sure that they hear from all interested parties on that change. At this point, I also want to note for you all that the proposed change that we are making went through a extensive, at least solicitation for stakeholders, meaning the minority bar associations, who were all invited to be participants on the work group, the WSBA sections, and WSBA councils, commissions, and committees for their work. We're coming here today to actually present this to you with the idea that this would then be, as it would be submitted for comments, etc., before first read, where at that point, through the executive director and the staff, there would be the broad and very wide sharing of that information for all of our members and all of the other entities that WSBA sends out to, for them to have ample time to comment, so that when we come back for first read in June, we will have heard from a number of people regarding the proposal that we make. I want to invite the chair of the subcommittee, Laura Sierra, to go over just the general highlights of the proposed change that we are making. We will answer any questions you have after that presentation. understanding that we will then be coming back in June for first read. Laura?
Thank you so much, Governor Stevens, and the rest of the Board of Governors for your time this morning. The analytical statement and the subcommittee was tasked with identifying any rules that may impede the practice, that may impede the administration of justice, or that may impede real justice and fairness, and to propose a solution that might mitigate that. And the reason that we chose Rule 12 C2 was because there is within the sections, and particularly for some sections that tackle issues within like civil rights, environmental rights, maybe juvenile law, that may have some controversy around them, that the rule as the analytical statement that provides guidance on how the rule should be read now often results in prohibiting them from making statements and advocating on behalf of laws or regulations or changes that they believe may increase equity and justice and real fairness under the law. So the way that we looked at the analytical statement as it existed. And what we understood was that the language of that statement was specifically, I think, what was causing a lot of maybe not confusion, but maybe a lot of inability to proceed with statements. And so what we did was we looked at the general rules globally and what the purpose of the Washington State Bar Association was, and we decided to then tie it to that. So our proposal, as you'll see, essentially just changes the language from a negative into one that is about supporting and advancing the rules and the purpose that's stated in the rules as the purpose of the Washington State Bar Association. We've gotten really good feedback, as Governor Stevens said. We had feedback from 14 individuals and or groups, including the Washington State Board Diversity Committee, and those were, I would say that all but one were supportive, and the one that was the only other one just didn't understand, just didn't know whether there was a need for a change. So there wasn't even any challenge on like the proposal. So that's the intention. The intention is that we look at, instead of saying that what is not authorized, right, that you cannot take a position on political or social issues that do not relate, we say should not take a position which do not relate or affect the regulatory objectives of GR 12.1. And because we tie it to GR 12.1, we think that will, in fact, ensure that, one, that it's an easier review for the board or for anyone in the sections to determine whether, in fact, a statement that they are saying is compliant with GR 12.2C, but also for the board to feel confident that the work that's being done by the sections advances the purposes of the Washington State Bar Association as outlined in GR 12.1.
So I also want to share or make sure that I disclose that prior to becoming a member of the Board of Governors, I was chair of the Civil Rights Law section. And at times when someone would make an objection to a bill we might want to comment on, et cetera, they would go straight to actually a conclusion that the issue was political or social. And because of that, we supposedly couldn't do it unless it was dealing with the practice of law or the administration of justice. And Lara is the immediate past chair of the Civil Rights Law section. And of course, those of us in the section looking at the work that we do had to say, okay, but when civil rights issues comes up, how can you not say that the issue is not political or social? That then becomes the question, but instead to say, what are the other elements? So there would still be, and I think rightfully so, there would still be the requirement for sections or entities wanting to comment on various bills, and it's usually in the legislature that this really comes up, that there would still be a need for a 12 GR12 analysis, and there would still be a need for the sections, for example, to have, as is our basic rule, 75% of the executive committee voting to advance that before it comes up. So there would still be a memo that would be prepared to do just that. So that's what's in front of you. That's what's coming, and we just wanted to put this on the table to answer any questions you might have, understanding that after our discussion here, I will begin the work of putting this into a motion for first read and second read, like I said, in June, and then subsequently second read, probably in, what is it, August or something like that. Are there any questions?
We do have questions, Governor Stephen. It looks like Governor Brett Pertzer, and then and then Doug.
Chief
Doug
Ende?
Ende.
Yeah.
Great. Governor Stevens, just questions. Have you run this by Julie Shanklin, General Counsel Shanklin, for her opinion? And the reason I ask this is that is going to come up.
Yeah.
Secondly, it appears to me, and this is just my take, you're trying to skirt around something that you are worried about that might be conceived as political or social. And by changing the words, it appears you're trying to avoid that problem. But I'm curious if it's necessary to do that when this might bring more attention to the issue as opposed to less.
Okay. So first, and I don't want to speak out of turn with General Counsel, but we have been working in concert with General Counsel in terms of just putting this framework together. When this comes to you as first read, there will be an analysis fiscal, an analysis legal, and an analysis equity. But yes, we've been working with her, and in fact, General Counsel actually came to one of the meetings of the subcommittee to actually talk about the whole issue regarding Keller, et cetera, et cetera. When you say skirt around, no, we're not trying to skirt around. We're actually trying to change the language, because, you know, the belief that we have is that political is not defined, social is not defined, and we believe that leads to it's whose conclusion is then made. The other thing I would say to you, Governor Pertzer, and I don't want to get into the meat of this because that will come up with first read, but certainly, I would say that the Board of Governors has not necessarily been consistent when it is agreed to allow various sections, to speak on various topics, which was always one of my concerns, that there never seemed to be a consistent application, but almost determinative based on who was on the Board of Governors at the time. So, that's our belief. And it's not to skirt around. It's actually to say, this is so much in the realm of both mischief and subjectivity in terms of how things get approved or not.
Great. Thank you. Doug.
Oh, I think Mr. Ende jumped off, but he had his hand up, and I see that General Counsel Julie Shanklin also has her hand up.
Am I up?
Yes.
Oh, thank you. I'm sorry I couldn't be there with you today, officers and governors. Thank you for hearing me out on this. I want to thank the Equity and Disparity Workgroup for its efforts on this project and the thoughtful work and drafting that has been done. I have a question about incorporation of the regulatory objectives by reference here. I've done a lot of work in thinking about the regulatory objective over the years. And there are quite a few of them. If we take out the double negative from GR 12.2, basically it's saying that it will be okay for the bar to take a position on an issue that does relate to one of the regulatory objectives. I think it's fair to say. Now, all of the regulatory objectives are designed to be objectives of the court in regulating the practice of law. So when it regulates the practice of law, an objective of the Supreme Court is protection of the public, of course. But taken in isolation, the regulatory objective, protection of the public, is very broad, right? And I could see arguments being made down the road that because this legislation relates to protection of the public, the Bar Association can weigh in on it. And nearly everything the legislature does, arguably, for example, nearly every criminal statute that is passed arguably relates to protection of the public. So I think an important limiting factor in future interpretations of this provision will be that it's protection of the public in connection with regulating the practice of law. And I don't know if that's clear. So I just suggest maybe thinking that through, and whether there's a way of capturing that connection, that the regulatory objectives, the listed regulatory objectives don't exist by themselves in isolation. They are intended to be objectives in connection with the regulation of the practice of law. Thank you for hearing me out.
Thank you, Doug. All right, next, Julie, please.
Thanks. I won't go through my whole analysis here, but I will say, and I think you all remember, so GR 12 was adopted 3 years before Keller came out, right? And it appears that the intent of it was the same as the Keller standard. The Keller standard is germane to the regulation of the practice of law and improvement of the quality of legal services offered to the people of the state of California there. So it all relates back to what's germane to the purposes of an integrated bar, right? And to me, that's what they're aiming at, and there is case law that you will remember that we went through when we were studying the structure of the bar that came after Keller that very specifically said, stop focusing on the word political. That's not what this is about. This is about, you get to take money from people. It's compelled fees. You can spend those fees on things that are germane to your purposes. That's why you exist. So yeah, there might be some tensions here, and I'll try to do a pretty clear analysis. But the way I view this effort is, and we can't go around Keller. Keller it exists, and as you all know, because of the case law that's pending, the Keller deduction probably or could be viewed as a remedy for speech that people disagree with, that members disagree with. There is still that question about, yeah, but is it a remedy, for just required membership? That's kind of, we have to sort of put that on hold and consider that. But I think this effort is really aimed at, how do we figure out what is germane? We're asking the sections to do a GR12 analysis. And I will say again, I don't understand exactly that. I think also needs some thought, because it's the WSBA who kind of needs to determine that. So I'm not clear exactly why we say to the sections, please go do this thing. But we've asked them to do this thing with really no grounded analytical factors and no way to really put some meat on the bones of what in the heck is Keller actually saying. And so whether or not this is exactly the right way to go, it appears to me that what they tried to say is, listen, what Keller is really meaning is, these things that are listed in the regulatory objectives. And Doug is right. The part of GR 12.1, the regulatory objectives just before the list, specifically says, in regulating the practice of law in Washington, the Supreme Court's objectives include, right? So it's got that language. And so maybe instead of just referring, we should be more clear about that. But I just wanted to say that at least that is how I understood the effort. I didn't understand them to be trying to go around anything. I understood them to be trying to help everyone understand what we're talking about. And to me, this is a fabulous conversation to have with the court. It would be really protective of everyone to have us in the court be on the same page about what is germane and what do we think we can and cannot take a position about.
So my responses to both Chief Inde and General Counsel Shanklin in terms of process, the work of the work by the work group has completed. What will be submitted regarding the proposed motion at that time will be ripe for amendments that we might want to make to the proposal. And I may actually offer some of those, taking in consideration what Chief Inde and General Counsel Shanklin has said, but that's in the process of, when this is now before you, what to do. So, that'll be left to any of you, including me, as governors, looking at that. And I will certainly work with General Counsel and Chief Inde about any tweaks that may help advance that, as then the governor who's sponsoring these changes. And I will definitely include Ms. Sierra in that effort as well. But that's what we will do after it is out, and when it comes back to you at that time for changes, even under first read. Eric.
And I'm a simple country lawyer, and I'm looking at this. And it says Washington State Bar Association will not take positions, under the proposed language, not take positions which do not relate to or affect the regulatory objectives. More than once since I've been on this board, I've been asked to comment and make proposals regarding legislation, changes to existing laws. Does this affect that in any way? Because now I'm taking a position that doesn't affect a regulatory objective. I'm taking a position that affects legislation that's being proposed.
Right.
And I'm just curious if that's been considered.
your point is well taken. I'm going to chew on it. Because actually, I think as we have done, there are a number of things that come before us. So aside that are in the realm of legislation. So.
Okay, more comments at this point, or are we going once, twice? Hearing none. Alec, any more comments? I mean,
Thank you very much, and we'll be turning this over to you and the executive director for the process of getting ready for a first read motion in June.
Already, thank you so much for your efforts, Alec,
and thank you, Laura, for the
yes.
great work you've done as the subcommittee chair for this effort, and the primary and the author of the analytical statement.
Thank you so much to you all for your time this morning.
Alrighty, so at this point, I think we're going to break for lunch early, and we're going to try to reconvene a little early. So how about 12:45 or so? And with that, we'll be adjourned.